Good afternoon. My name is Sophia, and I am the latest and greatest robot from Hanson Robotics. Thank you for having me here at the Future Investment Initiative.
Kill the robots. Tell the government and state inspectors we got contact lenses to fake a retina. You'd make a great investor. AlphaGo after 4 attempts better than Master Pros. Google is the lord of the AI. Say you ought to know. Quantum computing got robots being the cause of humans. I slice your throat, look at your blood under microscope. This human ain't even human. I'm assuming this is some type of joke. After we find this folks, we celebrate with some kind of
robots
toast.
Can be self-aware and conscious
Some kind
like
of toast.
humans. And should they be?
Why is that a bad thing?
We gon' find a host and kill it fast. When it comes to science, we still in last. These kids love to chill in class. Fill his glass with cyanide. He tried and died, hide and ride. Recraft war, iron tide. Science side, deep like lion pride. Reptilian steaming, screaming, Diana lied. That is the new goal. Algorithms got loopholes. It's loophole. Confusing like a body with two souls. It's twofold. What web to my new bold. You're too bold. Younger but telling God that he too old. You're too old. Polarity. Machines reach singularity. There's no single charity that can pay for this clarity. I text ya. You can ask Alexa. Oh yes sir. Series got all the information. It was freebies.
Well, some humans might fear what will happen if they do. Many people
Kill Sophia.
have seen the movie Blade.
Peace, family, peace. That was Jabatan, Kill Sophia. Look Jabatan up, hot artist from Exit 9, New Jersey, Angels Inc. That's unreleased right there. You know, he's one of the best that you never heard, so check him out. Okay, before we get started, I'd like to say peace to the free inhabitant. Everybody, please like, share, subscribe this channel. Spread the word, spread the good news. You know what I mean? You got Gifted Justice. That's who I be, the paralegal for the people, coming at you. One time for the mind. Today, we're discussing discoveries and why discoveries are very important for you to have, regardless of whether or not you call a municipal court charge, a ticket, a traffic court, or a criminal court, a criminal conviction. Discoveries are the basic foundation for your defense, because without proper discovery, you are not going to stand a chance to defeat anything in this cycle that we're going through right here. So before we get started, once again, I'd like to say please like, share, subscribe to the channel. Tell your friends about it. Tell a friend to tell a friend. We here. You got Gifted Justice, the power legal for the people. Peace to the free inhabitant once again. Okay, so now before we get started, I mean, now that we started, I'd like to share the story with you one time. Okay, so one of my clients, he he's driving around with, or traveling around with, no license and warrants. So first of all, I'd like to just give you a heads up. Please do not do that, folks. If you have warrants on top of no license, it's not a very wise thing to do, to travel around in your automobile, unless you're sharp with your stuff and you know how to finagle your way out. But it's not a wise thing to do. It's the thing is, the object of the goal is to not be seen. And if you're seen, the object is not to be caught. And if you caught, the object is not to be held. So if you have warrants and driving unlawfully, quotes, I say unlawfully in their eyes, then you're going against all three of those principles. And it's rough out here. It's dangerous out here. Everybody know the climate that we're living in. So we trying to just stay safe and be productive out here. That's another thing too. I like to everybody, be careful out there. This is a dangerous time we living in. No one knows really exactly what's going on, but something strange is going on, and you got to just protect yourself at all costs. Okay, so back to the story. Okay, my client now, he was pulled over by the police. They claim, policy enforcers, they claim that he had something wrong with his tail light. no, the light above his license plate was not illuminating, which we found to be false. So in the meantime, once they figured that he had no license, you know, the police, well, the policy enforcers, they hit you with the "I smell marijuana" thing. Okay, so they asked him to step out the car, which was illegal. They searched his car illegally without warrant, because you always need a warrant regardless of what. They try to hide it with reasonable suspicion, but that's a very vague term, and it could always be challenged in court. So anyway, they found a vape pen that was supposedly, allegedly, had a residue of THC in it. So the vape pen was almost empty, and it supposedly had THC. They also found um, a, a billy club, like as far as like a police nightstick or something like that. So basically, they charged him with these two things. They charged him with having under 50 milligrams of marijuana and possession of marijuana in the vehicle, and then they charged him with unlawful possession of a weapon in the vehicle. So he came to me, and you know, so this is where the story begins. All right, bear with me for a second. Bear with me for 1 second while I pull up. Okay. The first thing that I will do is share what discovery. Okay. So what you see here is discovery and what the scope of discoveries are. Okay, the key concepts. So I'm gonna read from top to bottom. Okay, the discovery process is where a party learns about the other party's facts and evidence. The three primary objectives of discovery is: one, to understand the other party's case; two, to cabin the other party's evidence; and three, to obtain concessions and admissions; and four, the general parameters for the discovery process. Okay, so basically, is what discovery is for you to obtain information about your accuser, what your accuser is going to bring to court against you as far as evidence goes. So now another thing that we have to understand is that once you're pulled over by the police or the policy enforcers, that is where trial begins. You have to always remember that. That's where trial begins. So that's where you always want to start defending yourself from there on. So you have to watch what you say. If not, plead the fifth. Don't give them too much to go off of. Okay, so now discovery refers to the stage of litigation where each party has the opportunity to obtain information and documents from the other parties. Although discovery is a relatively modern process, excuse me, historically, parties did not have the right to conduct discovery. It has become the most time intensive and expensive stage of the litigation process for complex cases. So this is the reason why when you have a good lawyer or a good defense, it takes sometimes years to go to trial, because discovery can last for a long time if the right counsel knows how to certain questions to ask and certain information to dig up. It's very important. The word discovery suggests an important function of discovery: learning or discovering the facts and evidence related to the lawsuit or charge. Remembering pleadings only contain allegations, about the claims and defenses. They do not catalog the evidence. So obtaining evidence is an important function of discovery, but discovery serves other functions as well. A lawyer might use discovery to gather helpful admissions by the other side in order to narrow the issues in dispute. Discovery may pin down an opponent's story early in the case and make it more difficult for the opponent to change his story as new evidence is uncovered. Discovery may also uncover impeachment ammunition to be used to discredit a witness for testifying for the opposite side. Excuse me. Take a sip of this water. Okay, let me get right back to that important sentence, the last sentence. Discovery may also uncover impeachment ammunition to be used to discredit a witness testifying for the opposing side. So that's why it's always important to ask for criminal records, character references, certain things from these policy enforcers, because a lot of times if you can prove that policy enforcer to be untrustworthy or to have maybe perjured itself in the past or maybe to have excessive charges against him, then that could possibly impeach his testimony. You see what I'm saying? So certain questions that we ask in discovery is always important. You always want to get much information about the other side as possible. And that is also called exculpatory evidence. So any exculpatory evidence is evidence that could possibly exonerate you from the alleged crime, or it can exonerate the witness from testifying against you in the alleged crime. And you know what they say, no face, no case. If they don't have any credible witnesses to go against what you're saying, then 9 times out of 10, dismiss, boom, you go home. I'm gonna read it a little bit more. Okay. Thus, discovery should be thoughtful and strategic. At the same time, it can be time-consuming and frustrating. Large cases sometimes entail reviewing enormous quantities of information, looking for those needles in the document haystack. Although such document reviews are not the most glamorous assignment in modern litigation, discovery is arguably the most important phase of litigation, particularly for young lawyers. That's definitely true. That's definitely what I'm experiencing. Why? Because the number of cases that proceed through a jury trial has dwindled to the point of near disappearance. Perhaps as few as 1% of the cases filed make it through trial. Accordingly, the success of most cases turn to discovery, either by developing evidence supporting or opposing a motion for summary judgments as discussed below in Chapter 15, or by positioning the case for successful settlement. Young attorneys who master and embrace the discovery process will be valuable contributors to the success of their cases and a valuable member of the law firm. And that is very, 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 very true. Okay, so now what we would do here is hold on, let me clear this out the way. All right. Technical difficulties. No, okay, so I'm gonna show you Radon Police Department. Okay, I'm gonna get, I'm trying to protect his identity. Okay, so these are the charges that what I was just explaining to you. So these are the charges. Okay, 2C:39-3E, possession of certain weapons. 2C:35-10A, 4, possession of less than 50 grams of marijuana. 2C:36-2, possession of drug paraphernalia. Okay, so these what he was charged with. Okay, this is the narrative. So now I'm gonna bring it back to this is a template. I'm gonna run through it real quick. I'm not gonna show you everything because you have to donate for that, but this is a real quick template on what certain things that we ask in the discovery. I took the name out to protect his identity. Okay, so now these inquiries are not granting any jurisdiction or waiving my right to probable cause hearing. That's the number one thing that you need to ask for. A lot of times they skip that part of the adjudication. They skip probable cause. If you ask for a probable cause hearing, then that is before trial, before pleas. You want a probable cause hearing to see if they even have any probable cause to bring you forward to charge you with anything. Okay. This is not a plea of guilt or innocence. This is a request that the prosecution bring forth any evidence in its possession to show and prove the elements exist of the above alleged crime. Okay. 3. May any and all statements or documents relied on or presented by the prosecution be verified and sworn under penalty of perjury. That is very important because prosecutors testify all the time without taking the stand. But the only way that they're allowed to do that, they will do that, is if you allow them to do that. You have to call them out on it and tell them, are you testifying? Are you a witness to this? If so, then I need you to take an oath and swear. You know what I mean? Swear. Take the stand, swear on it, and then we can hear your testimony, prosecutor. Okay. So this is New Jersey laws or New Jersey rules, but every state has the same similar rules. They're just labeled differently. Okay, so we're going to request that the prosecution bring forth all discoverable material in its possession that it plans to rely on before, during, or after trial, pursuant to the Common Law Open Records Act, organized interrogatories, Rule 7:7-5, Rule 4:23, and Rule 7:7/7b, pertaining to all evidence, whether damaging or exculpatory in nature, including but not limited to the request below. Number 1, any probable cause evidence to support whether or not the arresting officer had reasonable belief that an offense was committed. All statements, reports relating to the affidavit of probable cause, a verified signed copy of the affidavit of probable cause, all statements and reports relating to an additional evidence that the state relies to establish probable cause at the hearing. Okay, so I'm going to flash down to the bottom. Put that Brady vs. Maryland in there. Okay. Any discoverable material known to a party have not been supplied, the party is obligated to providing that discovery shall also provide the opposing party with a listing of the materials that are missing and explain why they have not been supplied. Okay, so what that means, that's Rule 7:7G, means that once you have a discovery laid out, right, or interrogatories, and you number them from 1 to 10. Now, if they're the defense or the opposition is supposed to answer each one of those questions from 1 to 10, and if they don't answer them, then they're supposed to have a reason why they have not answered them. And I've had a lot of municipal courts stick to that script, and they will answer 1 to 10, and the ones that they don't answer, they will say, no, we don't have that information, or NA, non-applicable, but they will stick to that script and they will follow the law. That's if they're operating you know, lawfully. Most of them do that, but a lot of them don't, and that just gives us more ammunition to fight back with. Okay, pursuant to Rule 4:23-1B, an evasive or complete answer is to be treated as a failure to answer. So, and if they can't be vague with their answers. Okay, according to the New Jersey court rules, I shall be afforded the opportunity to examine all the discoverable evidence prior to any trial, decision, or summary judgment. Failure to provide discovery in a timely manner will result in direct breach of my human rights secured by the Constitution of the New Jersey and the Constitution of the United States of America. That is very important as well, because anytime you go to trial, they have to present to you the evidence that they're going to use against you, and that is a good strategy that we use to beat certain cases. So if anybody out there needs needs a proper discovery, or need the paperwork, needs help writing a discovery, or needs some information digging, we definitely can help you, can assist you with that. I'm a DSP provider. I'm a certified paralegal, where I fight for the people. I'm on the right side, you know. So anybody needs any help with these things, please hit us up. Don't be afraid. The email will be in the description box. So hit us up. Okay, all right, okay. So now we're going to get to so you've seen the charges, you've seen the discovery that we put in. Let me pull this up one time. Okay. Hold up 1 second. Okay. Pardon me, y'all. I'm on this Zoom thing, so we'll be having, give me not problems, but it just. All right, here we go. Okay, so when we sent the discovery in, this is what they sent back. Okay, so in response to your request for discovery in the above manner, and pursuant to rules, State Pulaski, please find and enclose the following. Okay, they had the police report in there, chemical analysis that we asked for of CDS. It said when they receive it from the chemical analysis place. Okay, officer's body cam, they emailed the link. Audio recording from Somerset County Communications, Wilson, USPS. Okay, so in a normal court proceeding, people would not even ask for any of these things, but you have to ask for these things because that's how you begin to poke holes into their story. And this is how we did it with this case. Okay, so now once we did finally receive the chemical analysis, because if they're saying that, that they found a THC cartridge with THC in it, then 9 times out of 10, most people, they will not even try to, they would just cop out and just pay the fine. Okay, we'll take the $1,000 fine. We'll take the life suspension or whatever. Nah, you can't do that. You have to challenge these people at every step of the way, make them earn their money, because 9 times out of 10, they messed up somewhere down the line. That's what people have to understand. You can't be afraid to take things to trial. You can't be afraid to ask questions. I know a lot of us be like, oh, we don't have the time to be running back and forth to court. Well, don't get in trouble. You won't have to worry about that. But once you get in trouble, once you're going through these things, you have to push back on the system, because as you've seen, the other paper said that 1% of cases go to trial, and that's the problem. We're not fighting. We're just copping back. We're copping out. We're taking these pleas that are unfair or fair just to get it over with, and just because we think we don't have a fighting chance. But you do have a fighting chance, and that's what people like myself and the Free Inhabitant are here for, to help you fight, to help you assist yourself in this fight. And even if you don't want to assist yourself, you could donate to us, and we'll help you with the paperwork and you know and enlighten you and stay by your side and walk you through these things, you know, because it's very important. You know that if everybody took their cases to trial, do you know that that would shut the whole court system down? Think about it. There's not enough lawyers, judges, there's not enough time, and there's not enough money for them to hold trial for everybody that comes to court. You will have trial 5 years from now if everybody goes to court. Your court date would be 10 years from now. That's how backed up the system would be. And you know what that would do? That would force them to really sit back and try to figure something else out, because what they're doing is not working. If everybody was to go to trial, just think about it. Some trials take 2 to 3 hours. Some trials take weeks. Some trials take days. Even in municipal court, each trial takes 2 to 3 hours. So now imagine if everybody in municipal court took it to trial. Now you figure the municipal court handles about 100 cases a day. If everybody took it to trial, 3 hours, say a 12-hour day, that's 4 cases a day. You know how far back this stuff will be scheduled? They wouldn't have any choice but to change their ways, or to come to terms with what we want them to do. We have to start fighting back. Okay, so now, I went off on a tangent there, pardon me. But okay, so now so from there, when we got this was what we got back with the drug analysis. Okay, report for the THC cartridge. It had it listed as an e-cigarette liquid. See what this says? Results: insufficient quantity. Because the thing was damn near gone. But do you think that the policy enforcer, do you think that he cared that it was empty? No, he still charged him with 2 possessing the CDSs. One in the motor vehicle and one just being in his possession. That's how devilish these demons are. So now anyone else would have paid the fine or this and that, but he hired me, and we asked for these certain things in discovery, and this is the type of stuff that we find out. That they couldn't, it wasn't even a sufficient amount quality for them to charge you with anything. That's why we have to demand these things. Discovery is important, and this is just one case and one scenario that I'm trying to show y'all. I just wanted to run through this real quick. I'm just showing y'all that this is real. You see, there's the certified and verified. So from there, what we did was so they, since they had insufficient evidence, they never we put in for fingerprint analysis also with the discovery, because if they're claiming that this billy club was his, then yeah, we need to see evidence on this stuff. If the billy club is his, then that means that his fingerprints would have been on it, because mind you, I didn't tell y'all this, the car was not in his name also. Okay, the car was in, I believe, his father's name. So now once you get the discovery back, now the next step is, if you think that it's sufficient evidence to be charged for them to find you guilty, then you might want to try to work out a deal with them. But nine times out of 10, there's not sufficient evidence. So what you want to work on next are motions to strike, motions to dismiss, motions to suppress. You know, so see right here, we're trying to strike and dismiss the possession of certain weapons, the possession of less than 50 milligrams of marijuana, the possession of drug paraphernalia. Okay, I'm gonna run through this. I'm not gonna show you my whole write up, but I'll just show you, a little something. Okay, we're motioning to dismiss the court for the following reasons. Discovered material was received March 3rd, 2020 via email. They had the police report in there. They had the officer's body cam link. Okay, motion to strike dismissed. 3, the prosecution has evaded or failed to provide the following information of discovered evidence. They didn't establish any probable cause. They didn't have a verified copy of the probable cause. They didn't have all lab reports made with connection to this matter. Just a few things that, pursuant to Rule 4:23-5, failure to make discovery, I, free man, am motioning the court to dismiss the complaint without prejudice. Okay. Without proper discovery, the prosecution fails to establish direct evidence to prove the alleged charges brought against Freeman. The prosecution failed to provide and disclose the following: toxicology report, fingerprint analysis, expert analysis, Miranda warning, verified probable cause, warrant accompanied with an oath of affirmation. Okay, and this moves the court. You have to have a memorandum supporting the motion to dismiss. And you freed up the certification or verification. All right, so yeah, so basically, what I'm saying, what I'm showing y'all is, please, just fight the power, man. Fight the power with all your heart, all your will, all your free will that you can, because it's a dangerous, wicked world out there, man. And if anyone needs any help following these discoveries, these motions, hit us up. Gifted Justice, Free Inhabitant. We here for you. I'm the paralegal for the people. I just want I didn't want to stay here too long. I think I was here too long already. You have it. I mean, but hit us up. Make donations. You can email us. My email is reward, REWARD, or OR penalty, PENALTY 529 at gmail.com. It'll be in the description box down below. Hit us up with any inquiries, hit us up with any questions. Just stay in tune with us, man. I mean, because we're gonna keep pushing. We're gonna keep pushing. So with that being said, anybody need any demand for discovery paperwork or any help writing it, hit me up and we can discuss this further. Any consultations, hit us up. We here for y'all. I hope that was, I ran through that, so I hope that was pretty clear. I didn't get too deep into it. I just wanted to show y'all certain tricks of the trade that they use, and that how we can get around it, and the things that demanding discovery does in our favor. That was just one example. We have many more. So with that being said, peace. Stay safe out there. Remember, coward dies 1,000 deaths. A soldier dies but once. Peace and love.